Hello friends, I am here in the Academic Forum of Confident Law Classes for Judicial Services. This forum is relevant for all the students appearing for UPSC examination also, or whoever is interested in polity, constitution, and obviously constitutional law. And in this forum, we discuss the Supreme Court decision. The controversy is that some media persons have accused the Supreme Court of gagging the media. A decision that the Supreme Court has given seems to be restraining media from irresponsible reporting. And in fact, this has become a menace. And that is why the Supreme Court took a very strong notice of this and gave this order. So this was a case, a writ petition, in which the main question was welfare of the migrant laborers who have been displaced because of the lockdown. But the question is that, is this lockdown the real cause behind this, or something else happened? Now, according to the Solicitor General, as he said before the Supreme Court yesterday, that it is because of the fake news, fake alarm, false alarm created by certain sections of the media. And that is true also. So all the clips were presented before the Supreme Court, on the basis of which the court has given this decision. So here the Supreme Court has simply said that Section 54 of the Disaster Management Act is applicable here, which says that anyone, any individual or any institution raises a false alarm, creates a panic among the people, then this is a punishable offense. And the punishment can go up to a maximum of 1 year. So this is there in the statute itself. So the decision given by the Supreme Court is not a novelty. It's not an innovative decision. It's not something that the Supreme Court has done out of the blue moon. Rather, there is a statutory framework already in existence. The National Disaster Management Act 2005 clearly mentions that whenever there is a false alarm raised, and in fact this is a health emergency situation, we all know that, and it has created a panic. And what panic was created? That some sections of the media had reported that probably the lockdown would continue for 3 months or beyond that. Now these migrant laborers who had no other source of income, they were daily wage laborers, were obviously scared of this situation. They became apprehensive. They also became apprehensive because of this pandemic, that the pandemic may affect them. And therefore, they started rushing towards their hometowns. Given the fact that the lockdown had been declared and all the transport services had been called off, now these people started walking through various boundaries across the cities. And therefore, the danger of spreading the coronavirus became even aggravated. So it increased. And therefore, it became an alarming situation for the government. The Supreme Court has given a very, very appropriate order. It says that Section 188 of IPC will also be applicable here. So whoever violates any order given by a public servant in this regard, where the public servant has the statutory authority to do so, then that person will be punished. So 188 of Indian Penal Code, Section 54 of National Disaster Management Act. The media houses did not maintain that decency. Rather, they sensationalized the matter. And therefore, the Supreme Court has asked them very strictly to consult the government before publishing any report on this issue, on coronavirus or its spread. So if they have to publish anything in respect of coronavirus, in respect of all these things, then they will have to first of all see the government portal, whatever information the government has provided, which is an authentic source. Now, there is no prohibition on the media house to do its own investigation. It can do, but it can do so only on the condition that it should produce evidences to show that the government data is wrong, is erroneous. Unless and until the media houses enter into this investigative journalism, they have no right to make surmises, conjectures, guess. All that the Supreme Court wants here, that the media should consult the government authorities, the government bodies, from where verified, warranted and authentic news can be gathered. So Press Information Bureau is there. Ministries are there, so they can be contacted. And at the same time, the Supreme Court has also asked the government authorities, within 24 hours, they must give entire data. A daily bulletin should be started where on a day-to-day basis, the government should pass on the information that it has in the public domain. So the moment that information is passed into the public domain, the media houses can see them, and on the basis of that, inferences can be drawn, conclusions can be drawn, analysis can be done. Now the question is that why did the Supreme Court do this? Here, there is a constitutional justification of this. Article 19, Clause 1 gives the rights to the people. So, the citizens of India have certain fundamental rights guaranteed to them by Article 19. So, Article 19(1), that the people, the citizens of India shall have right to freedom of speech and expression, which includes the freedom of press. But at the same time, Article 19, Clause 2 says that on certain grounds, reasonable restrictions can be imposed on the right to freedom of speech and expression. So what are those grounds? I won't mention all of them. You can see Article 19, Clause 2 yourself. One such ground is sovereignty and security of the state, defamation, contempt of court, decency, morality, friendly relations with other countries, public order. So public order is a ground. So wherever it appears that right to freedom of speech and expression is being exercised in such a manner that it is detrimental to public order, it destroys public order or ruptures public order, then restrictions. So here we see the panic that was created by the media houses ruptured the public order. Public order includes public tranquility, public safety, public peace, law and order, right? In fact, Justice Hidayatullah in one of the cases has held that law and order, public order and security of the state, they all are related to one another in three concentric circles. So the bigger circle is law and order, smaller circle is public order, and the smallest one within that is security of state. So whenever security of state is endangered, this is violation of public order. Whenever public order is endangered, this is violation of law and order. So every violation of law and order may not be disruption of. We have understood the relationship here, concentric circles. The largest circle is law and order. Then within that circle there is public order, and within that circle, the interior-most circle, is security of state. So what exactly public order means? Public order means public peace, public tranquility, public safety. It also signifies that everything is done in accordance with the provisions of law. We know that there are certain rules and regulations made by the government. So if everything is happening in accordance with the provisions of the law, then we say that there is public order. So here, the lockdown had been declared. So, according to the National Disaster Management Act and the Epidemic Act, certain rules should have been followed. Certain rules should have been observed and obeyed. Now that the panic created by the media encouraged the people to violate these rules and regulations, so it is violation of public order. And therefore, reasonable restrictions can be imposed on the right to freedom of speech and expression. And that has been done here by the Supreme Court. So there is nothing. You can make references to the cases like Ramesh Thapar versus Union of India. Ramesh Thapar versus State of Madras. You can also see any internet material on public order, how public order has been explained by the Supreme Court in various cases. But here, the main concern is that whether the Supreme Court's decision of restraining media from publishing unverified facts is justified or not. So just now we have learned that it is justified. 19 Clause 2 puts reasonable restrictions on the freedom of speech and expression. National Disaster Management Act 2005 and Epidemic Act. So all these taken together, the constitutional provisions and the statutory provisions, justify the restraint imposed by the Supreme Court on the media. So you can't call it gagging the media. Media has not been gagged. The Supreme Court has very expressly mentioned in this. The media is free to express its opinion. It has the freedom to discuss, analyze, have a debate, but then that should be based on correct facts. That should be based on the true facts. On the facts, rather. It should not be a fabricated fact, or the fact itself should not be the result of a conjecture. So I hope the judgment that the Supreme Court gave, the order is clear to all of us, and the constitutional and statutory provisions involved here. The name of the case is Alak Alok Shrivastava versus Union of India. So thank you. We will meet again for another case.